So good evening, everyone. Welcome to this webinar by Pushpanjali Trust. Pushpanjali Trust is a public charitable trust based in Chandigarh, and we've been working in the area of mental health and disability for the last 5 years. Our focus areas are awareness and advocacy for the rights of persons with mental disabilities. And we also try and facilitate rehabilitation of persons with severe mental illness. Some of the families had been asking us for a couple of years now to take a session on financial planning and private trust. Therefore, this session as a public outreach. Last year, we had conducted a similar session where we invited two guest speakers, Mr. Vijay Nallawala from Mumbai and Mr. Amrit Bakshi from Pune. And they spoke about this and in particular about some of the financial investments that can be done. This current session will be more about why do we need a private trust and the logistics around it, some of the misconceptions around it, the advantages, and some of the perceived disadvantages. So we'll start. Sorry, slide technical challenge. I'll ask Gurpreet Singh to help me with this. I am unable to move to the next slide. Just a second. Technologically, I call myself a Luddite. So Gurpreet Singh helps me with that. Now, right at the beginning, disclaimer. This is purely a basic awareness session on private trust. Please consult your lawyer or CA before forming a trust. I am neither a lawyer nor a CA. I have read up on private trust. I know a couple of families who've been doing private trust for their family members for a few years now, so gained from their experience. Spoken to a few lawyers, a few CAs, read up on the internet, spoken to a few trusteeship companies. So that's how I have learned from different sources. So this is purely a basic awareness session. It should not be construed as advice to set up a trust or the modalities around it. Okay, so who is the webinar addressed to? It's basically families of persons with mental and intellectual disabilities. Mental illness, intellectual disability, or multiple disabilities. And within these types of disabilities, it could be different degree of disability, mild, moderate, severe. So whatever financial planning families are planning, thinking of doing has to be tailor-made. There's no one size or one model fits all. So kindly be mindful of the type of disability and the degree of disability and what are you wanting to do. So why private trust or why financial planning? Why is there a need to secure the financial, legal, property interests? So the starting point is that the person with mental or intellectual disability may not be able to handle his or her finances, preserve his or her legal interests, property interests, and therefore there is a need to secure these. There's a need to secure the financial interests, there's a need to secure the legal interests, and the immovable property interest. Now, things like private trust allow you to do all three, but it's also possible to do one or the other. And what is also to be taken into account is the agency of the person with disability. How much would you want the person with disability to have control over his or her financial interests, property interests, legal interests? So therefore, as I said in the beginning, it's not one size fits all, one model fits all. Every family situation will be different. Every individual situation will be different, but we only have say 5 or 6 options available. So you'll have to choose between those 5, 6 options. But yes, even within that option, there's a lot you can do. So for instance, with private trust, how you frame the trust deed, God is in the details, as they say. So it all depends on how you frame the trust deed and who you keep as trustees. Now, let me also say, and it pains my heart to say this, that when we say the need to secure financial property interests, we are only talking about the middle class to upper middle class families, which is about 20% of the Indian population. So roughly 30 crore households in India, ballpark rough estimate 5% families with mental and intellectual disabilities. So that means 1.5 crore families or persons with disability. And we are only talking about the top 20% because only they have the means and the resources to plan, to have some financial planning, they would have some property. The remaining 80%, it's extremely unfortunate that they probably do not have the means or the resources for future financial planning. So essentially, we are talking of middle to upper middle class families, which will roughly be 25 to 30 lakh families / persons with disabilities in India. Now, what are the options available? So let me start with the simple options. Simple option where you only want to secure the financial interest of the person. So the simplest is the individual account, individual bank account, and individual permanent account number for income tax purposes. Then there is a joint account, the person with disability along with a family member or a trusted relative. So there's a joint account. And what are the instruments available? A bank fixed deposit, a postal deposit, and in some cases where it's a government employee, or in very rare cases, some of the private companies, well-established companies, there's a provision for disability pension. Then, as was discussed in the session by Mr. Vijay Nallawala and Mr. Amrit Bakshi last year, investments in mutual funds, stocks, and bonds, they also take care of inflation, and there is an appreciation in future. There is also a last option here, which is the annuity plan. Now, this is a great feature, and annuity is where you deposit a certain sum of money with the annuity company. It could be LIC, a public limited firm, for instance, Life Insurance Corporation, or some of the banks also do it, and some of the private mutual fund companies also. An annuity is where you deposit a certain sum of money, a corpus, and then you start getting a monthly income. And there are different kinds of annuity plans. So for now, just sort of be aware that there is also an annuity option, and those who are interested, I would recommend future research. But there's one particular annuity plan that I know a very senior person is using for his daughter, and he's very happy with it. So this is kind of tried and trusted for the last 2-3 years. It is called the LIC Jeevan Akshay number 7 annuity plan for monthly pension. And within that, there are several options, deferred payment, joint account, money returned at the end. So a lot of technicalities. Right now, my purpose is just to let people know that annuity plan is an option. And those who are interested, please do your research. So this gentleman has been using this for the last 2 years plus, and he's very happy with this. And this particular option that he's using is option G, which is immediate annuity for life, increasing at a simple rate of 3% per annum. So just taking this as an example, so under this scheme, what would happen? Under this scheme called the LIC Jeevan Akshay 7 annuity plan for monthly pension, let's say LIC would, depending on how much monthly pension you want. So let's say the family says, I would want a monthly pension of 33,000 to begin with, and the LIC does its calculation and says, okay, you'll have to deposit 2 crores as corpus or 1.5 crores as corpus. And what this means is the option G, that this person, the person with disability, starts getting a monthly pension of 33,000 from the very next month, and it increases 3% per annum. So for 33,000 monthly pension, there will be an increase of 1,000 rupees every year. So it will be 33,000 per month the first year, 34,000 the second year, 35,000 the next year. And let's say this person has a lifespan of 25 years. So it will go on from 33,000, probably 58,000 till this person passes away. And then there is no more payment or no money returned to anyone else. So that's what it means. Immediate annuity for life, increasing at a simple rate of 3%. But as I said, there are different options. Annuity plan is generally considered to be the best plan and the least hassle-some for a person with disability. Whereas things like fixed deposit, postal deposit, every 5 or 7 years, you'll have to renew it. The rate would change. For mutual funds, stocks and bonds, someone has to keep a check, keep an eye on those investments. Whereas annuity plan, जिसको बोलते हैं कि बिल्कुल भी झंझट नहीं, आंख बंद करके, और ये जो हमारे बहुत सीनियर कोलीग हैं, इन्होंने 2 साल हो गए इनको इसका एक्सपीरियंस करते हुए. So I'll now come to why do we need a private trust? The options that I discussed earlier just now only secure the financial interests. They do not secure the legal and the immovable property interests. So private trust, to my mind, and this disclaimer or the caveat again, my knowledge is limited. I thought whatever limited, because people had been persuading us, I will share. So my knowledge is limited. When we throw it up for question and answers, and if people have some other experience or want to add to it, please do. So a private trust secures all the following: the financial interest of the person with disability, the legal interest, and the immovable property interest. How it does it, I'll just come to that in a moment. Now, there is a lot of confusion between private trust and a public charitable trust. Although both of them are governed by the Indian Trusts Act 1882, but there are a lot of differences. A public charitable trust, for instance, Pushpanjali Trust is a public charitable trust. There is Sambandh Foundation in Delhi, it's a public charitable trust. Most of the NGOs are either the non-government organizations working for public at large, are either public charitable trusts or they are charitable societies, registered charitable. The beneficiaries there are public at large, and whatever assets you put in a public charitable trust belong to people at large. You can't take them back. However, the fundamental difference with private trust is that private trust is private. Here, the beneficiaries is not public at large. The beneficiaries are limited. These are individual beneficiaries. So it could be one individual or it could be 5 individuals as mentioned in the trust deed. So fundamental difference: public charitable trust is for public at large. Private trust is for the benefit of only a few individuals, 1 or 2 or 3 or 5 individuals as mentioned in the trust deed. A public charitable trust, if it has ATG, gets income tax rebate. They don't have to pay income tax. Whereas private trust, you have to pay income tax. There is no rebate. Some of the other features are that private trust allows you for asset protection. बहुत पेरेंट्स को होता है, गार्डियंस को होता है कि ये प्रॉपर्टी संभाल नहीं पाएगा, कोई इसको फुसला के साइन ना करा ले पेपर्स पे, अंडर द इन्फ्लुएंस ऑफ ड्रग्स और अल्कोहल और व्हाटएवर, कहीं बेच ना दे. Private trust allows you for asset protection. The beneficiary, जिसके benefit के लिए ये private trust है, वो इसको बेच नहीं सकता, इसको उजाड़ नहीं सकता. So this is the advantage of a private trust, that it allows for asset protection. It also allows for continuity of family wealth. You want to pass on the house or some other property to future generations. So you can mention it in the trust deed कि ये अगली 2 generations, अगली 3 generations तक जाएगा, तो फिर इसको कोई बेच नहीं सकता, ट्रस्टी सिर्फ इसका ख्याल रखेंगे. So asset protection, continuity of family wealth, these are the advantages of a private trust. Now there are different types of private trust. So one, of course, as I said, God is in the details. हम उसको किस तरह trust deed में terms define करते हैं, सारा उसी पे निर्भर करता है. So there is a special needs trust, which is for a person with special needs, a person with disability. It could be an elderly person suffering from dementia or Alzheimer's. So basically, special needs trust caters to person with special needs. Another very important feature distinction is whether the private trust that you create is a revocable trust or an irrevocable trust. Irrevocable trust is कि एक बार बना दिया तो फिर वो irrevocable है, वो खत्म नहीं होगा, वो चलता जाएगा जब तक हमने वो लिखा है कि उसका पर्पस क्या है. तो मान लीजिए ट्रस्ट का पर्पस है for the benefit of the needs, monthly needs, annual needs, medical needs, recreational needs of this person, the beneficiary, the person with disability. And the trust must function till his or her lifetime. So as long as that person is alive, no one can close the trust. The trust will go on. And then it will have to be mentioned that when the person is no more, the proceeds will go to A, B, C. So irrevocable is कि trustees उसको in future बंद नहीं कर सकते. Whereas a revocable trust, जिसने ट्रस्ट बनाया है उसको बोलते हैं सेटलर या फाउंडर ऑफ द ट्रस्ट. वो मान लीजिए 5 साल बाद परिस्थिति सिचुएशन बदल जाती है और 5 साल बाद उनका मूड बदल जाता है और उनको लगता है कि मेरे को अब इस ट्रस्ट की यूटिलिटी नहीं रही, सो ही कैन रिवोक द ट्रस्ट. ट्रस्ट को बंद करके वही प्रोसीड्स बेनिफिशियरी के अकाउंट में डाले जा सकते हैं. सो दिस इज अ वेरी इंपॉर्टेंट पॉइंट ऑफ डिस्टिंक्शन, a revocable trust and an irrevocable trust. Why should families choose one or the other? As I mentioned in the beginning, every family will have to put their mind कि हमारी needs क्या हैं, how much can we think about the future, 10 साल बाद situation क्या होगी, 20 साल बाद situation क्या होगी, क्या हम ये ऑप्शन रखना चाहते हैं कि ट्रस्ट को रिवोक कर सकें, बंद कर सकें, या हमें लगता है कि ये बहुत ही सेफ इंस्ट्रूमेंट है और हमारे पास ट्रस्टवर्दी ट्रस्टीज हैं तो हम इसको इररिवोकेबल बनाएं ताकि हमें पता हो कि एसेट प्रोटेक्शन इज फॉर लाइफ टाइम. Likewise, there is another feature called discretionary trust. तो या तो शुरू में ही मेंशन किया जा सकता है टर्म्स एंड कंडीशंस वेरी क्लियरली कि 60% for monthly expenses, 20% reserve, 20% back to the corpus so that the corpus keeps growing. You can have it very black and white, very fixed, or it could be few things can be left open to the discretion of the trustees and the future trustees. कि अगर उनके कोई ट्रैवल एक्सपेंसेस हैं या मेडिकल एक्सपेंसेस बहुत बढ़ जाते हैं तो वो थोड़ा सा रीअरेंज कर सकते हैं. That again depends on how the family perceives its needs, how much they trust their trustees and the future trustees. So discretionary, how much discretion you want to have, or how much you want to put things fixed, black and white, not to be changed in future. Now, what are the modalities involved in creating a private trust? Most importantly, at least 2 trustees. More than 2, it could be any number, 5, 7, 9. But beyond 3 or 4, it becomes unmanageable, unwieldy. Trustees मिलेंगे, उनकी मीटिंग होगी, बातचीत होगी, तो 3-4 trustees से ज्यादा होने का कोई फायदा नहीं लगता है. But minimum 2 is a requirement. So say between 2 to 5 should be a good number. So very important to identify the trustees and what number, anywhere between 2 to 5. 5 I am saying seems reasonable, but if people want to have 7 or 9, that's also a possibility. There is no upper limit. Then the need to identify beneficiaries. So one could be very simple, clear cut, that the beneficiary, the sole beneficiary is the person with disability. Simple. In some cases, families also keep other family members as beneficiaries. Or unfortunate part, if there are 2 or 3 family members in the family who are persons with disabilities, then those 2 or 3 could be the beneficiaries of the special needs trust, the private trust. So you will have to define and very clearly specify that who are the beneficiaries. Then the trust deed. ये सारी terms conditions के trust का purpose क्या है, monthly expenses कहाँ से आएंगे, किस तरह का खर्चा होगा, कहाँ ये आदमी या औरत रहेगा, इनका फ्यूचर की क्या नीड्स हो सकती हैं, ट्रस्टीज की क्या पावर्स हैं, मैनेजिंग ट्रस्टी की क्या पावर है, बाकी ट्रस्टीज की क्या पावर्स हैं, फ्यूचर ट्रस्टीज कैसे अपॉइंट करेंगे, उसके क्या मेथड होगा या क्या क्राइटेरिया होगा, ये सारा कुछ ट्रस्ट डीड में लिखा जाता है. Then the identification of the assets to be transferred to the trust. The financial assets, the money part, that's the easiest, the liquid assets. And most people prefer that most of the assets should be liquid assets. You know, Kalko, this person with disability may have to change the city, may have to go to a rehab center, may need some medical attention which is better available in a neighboring city or somewhere else. You know, so the general advice of people at large, including lawyers, CA, financial advisors, and families who form the private trust, is that as far as possible, maximum assets should be liquid assets. It could be bank FD, it could be the annuity plan, it could be the mutual fund, stocks, bonds, liquid assets that you could immediately convert into cash. And the trust deed must have, and it's a requirement, must have a dissolution clause. ये trust का purpose है beneficiary की upkeep, beneficiary की देखभाल. तो जब beneficiary ही नहीं रहेगा, तो then the trust will close down, and it will have to be specified.
Trustworthy.
Kindly mute yourselves. So the trust deed will have to specify in the dissolution clause, once the beneficiary is not alive anymore, where do the proceeds go? It could go to the other family members. It could go to some public charitable trust. It could go to basically anyone that is mentioned in the trust deed. But it should be, sorry. It should be clearly specified that once the beneficiary is no more, for whose purpose, whose upkeep the trust was created, where would the proceeds go? So that is mentioned in the dissolution clause. The most important part, choosing the trustees. It's but obvious, but still needs to be said, the trustworthiness. Who are the people you find most trustworthy? It could be the siblings, it could be some family relative, it could be some family friend, extended family. You will have to find 2 to 5 people who you find are trustworthy. The other factors to take into consideration while choosing the trustees are, they should be available. You know, try as far as possible that they are in the same city where the person with disability is living, and there is some regular communication. ऐसा ना हो कि 3-3 महीने या 6-6 महीने बातें नहीं होती. तो महीने में एक बार, 15 दिन में एक बार, 2 महीने में एक बार, जो भी आपको ठीक टाइम रेंज लगे, communication honi chahiye with person with disability or the family. So availability and communication. The age and experience of the trustees. कि उनको थोड़ा एक्सपीरियंस होना चाहिए ट्रस्ट प्रॉपर्टी मैनेज करने का. एकदम इट शुड बी अ 21-year-old or a 25-year-old. Although it's also important that as the person with disability ages, and let's say the person with disability is in his or her 50s or 60s, at that point of time, it's also important to have a trustee who is 10 to 15 years, perhaps 20 years younger. तो कई बार जैसे मैं 2-3 ट्रस्ट जिनको जानता हूं जो चला रहे हैं प्राइवेट ट्रस्ट, वो ट्रस्टीज आर अ फ्यू इयर्स ओल्डर देन द बेनिफिशियरी, द पर्सन विद डिसेबिलिटी, एंड नाउ दे आर इन द प्रोसेस ऑफ लुकिंग फॉर सम यंगर ट्रस्टी, विच इज फाइन. तो ऐसा नहीं होगा कि आज पेरेंट्स या गार्डियंस प्राइवेट ट्रस्ट बनाते हैं और ट्रस्टीज बनाते हैं तो उनको आज ही पता है कि पर्सन विद डिसेबिलिटी से 20 साल छोटा कौन सा ट्रस्टी होगा. नहीं, एकदम शुरू में सारी चीजें पता नहीं होंगी, बट as years go by, once you start aging and you are in your 60s and 70s, you could look for a younger trustee and then define in the trust deed what would be the criteria of finding a younger trustee, or so all those things need to be defined and written in the trust deed. So as a person with disability ages, the beneficiary ages is in his or her 50s, 60s, it is important to have a younger trustee also who's 10 to 15 years younger, possibly in their 30s or 40s. But some experience, it shouldn't be a 19-year-old or a 21-year-old. It's also very important that the trustees are independent. There is no conflict of interest. तो एक दो ऐसे प्राइवेट ट्रस्ट भी मेरी जानकारी में आए हैं जहां, so let's say family has a person with disability and 2 siblings, तो वो जो 2 siblings हैं वो trustees भी हैं और beneficiaries भी हैं. तो ये एक बड़ा clear conflict of interest हो जाता है. Therefore the suggestion or the advice given by people is that keep things simple, very clear cut. Beneficiary और trustees का role different है. आप ट्रस्टी को ही, अगर वो सिबलिंग है या फैमिली मेंबर है, उसी को ही बेनिफिशियरी भी ना रखिए. बेनिफिशियरी सेपरेट होने चाहिए, ट्रस्टीज सेपरेट होने चाहिए, ताकि कॉन्फ्लिक्ट ऑफ इंटरेस्ट कभी आए ही ना. नाउ देयर आर आल्सो सम फैमिलीज वेयर single child, single persons, so the person with disability has no siblings, or the sibling is abroad, settled abroad. What do? And they don't have 2 or 3 or people in the extended family, among the relatives, family, friends who they find are trustworthy, or they're simply not available. People are so busy in their lives these days. Then there is also, so for them, there is an option of a professional trustee or a corporate trustee. So most of the big banks, HSBC, ICICI, they have called a trusteeship company. They charge a fees, a fat fees. So this is really an option only for sort of, if your assets are large, because they would charge a fat fee. But in case you don't have an option, then corporate trustee or a professional trustee is the only option there. Now, what are the logistics involved in creating and registering? So one is you will have to, after identifying the trustees, the beneficiaries, the assets to be transferred, the trust deed, you will have to register it with the local registration authority. The trust will have a separate bank account, and for a trust, it's a current account. Now, the beneficiary, the person for whose benefit this trust is created, can also have a separate savings account in his or her name. Possible. A person with disability can have, there's a misnomer, there's a misconception that a person with disability cannot have a bank account in his or her name. Can have a savings account. So a person with disability can have a savings account in his or her name, and parallelly also have a private trust. But for a private trust, the only option is a current account with the bank. पर मान लीजिए आप प्राइवेट ट्रस्ट का और मान लीजिए पर्सन विद डिसेबिलिटी का सेविंग अकाउंट नहीं है, सिर्फ करंट अकाउंट प्राइवेट ट्रस्ट का है, और अगर आप एफडी खोल के डाल रहे हैं प्राइवेट ट्रस्ट की, तो एफडी का इंटरेस्ट आपको उतना ही मिलेगा. सिर्फ फर्क ये है कि सेविंग्स अकाउंट में वो जो आपको 4-4.5% सेविंग्स के बैलेंस में मिलता है, वो करंट अकाउंट में नहीं मिलता. That's the only difference. The trust will have a separate bank account. The trust will have a separate PAN. The trust will have to file separate IT returns. Now, assume this person also have an individual income and going to the individual account, and this individual also have the private trust. So there will separate IT returns will have to be filed for the individual account and for the trust account. Audit is optional for up to a certain income of the trust. Beyond a certain income, I am forgetting what that income is. I think it's a sizable income, that is the trust has 1.5 crore income annually. Then there is a requirement by law to have it audited. But if you are taking the services of a CA to file the IT returns of the private trust, it is recommended that you also get the audit done for a small additional fee. Just to ensure transparency, just to ensure that, things are followed and trustees are not falling behind. Now, this very important question of transferring immovable property to the trust. So this is really for those families where there is a house, or they have a shop or some commercial property, rental income generating property, and they want that the person with disability should also get his or her due share in the house, in the rental property. So one route is through the will. So let's say the parents write a will, register the will, and they say that they have 3 children, 2 children, sort of no disability, and third person with disability. So they write that 1/3 of this will go to this person's private trust. So this is the will route. The second possibility is immediate transfer. Sometimes there are families who don't want the will to be contested, and there have been cases where even a registered will gets contested, and then the cases keep piling on in the court. And so there are some families who prefer कि immediate transfer हो जाए. उसमें slight negative thing is that there are stamp duty charges to be paid. Some families go ahead, do that. Others therefore prefer the will route. So one option also is, which mostly CAs and lawyers would recommend, कि आप trust तो अभी शुरू कर लीजिए, trust की wait ना करिए. Some families trust भी वो will में लिखते हैं कि will जब after we are no more, then this trust will come into operation. Whereas the lawyers, CAs I have interacted with, they suggest that please start the trust now, transfer some financial assets, some money, whether it's mutual funds, stocks, bonds, annuity plan, FD, whatever it is. And the immovable property can come through the will route so that you save on stamp duty charges. But then there are some families who want to play very safe, and then they say, no, we want immediate transfer. We don't want the will to be contested. Now here I would, now the UT families from UT Chandigarh who are considering the private trust. UT Chandigarh, there is a particular anomaly. UT Chandigarh is one of those few UT states where there is no stamp duty charge for immediate transfer of property within family members. So let's say husband wants to transfer 50% of the share of the house to the wife or to the son. He can do that immediately, and he won't have to pay the stamp duty charges, which vary from 2% to 5% of the property. Whereas in UT Chandigarh, there is no stamp duty rebate for private trust. So this is an anomaly. So what we are doing is we've started a small campaign where we have sent a representation to the UT Chandigarh administration कि जो रियायत आपने, जो रिबेट आपने स्टैंप ड्यूटी चार्ज में फैमिली ट्रांसफर को दी है, फैमिली मेंबर्स को दी है, सो कॉल्ड नॉर्मल मेंबर्स, नॉन डिसेबल्ड, वही रिबेट आप प्राइवेट ट्रस्ट ऑफ अ पर्सन विद डिसेबिलिटी, प्राइवेट ट्रस्ट ऑफ अ फैमिली मेंबर विद डिसेबिलिटी को भी दीजिए. तो मान लीजिए पेरेंट्स वांट टू ट्रांसफर द शेयर टू their ward, their disabled ward, but instead of transferring it to his or her name, and putting the property to risk, they would want to transfer to the private trust of their disabled ward. Usko bhi stamp duty rebate milni chahiye. So we've started sending representations, and this will be a small campaign from our side, so that there is parity between family transfer non-disabled to family transfer private trust disabled person. Now, what are the perceived disadvantages of a private trust? Some people perceive that it is cumbersome. अब मैं trustees ढूंढूंगा, फिर trust deed बनाऊंगा, और उसमें सारा future की possibilities, it's not possible to take into account all those future possibilities. Then the logistics, PAN, bank account, uska IT return file karni. But to my mind, it is essential that we, don't put the cart before the horse. These are small details. Don't be lost in those small details, the small logistics. The most important question to figure out is कि क्या हमें private trust की जरूरत है? और अगर जरूरत है तो ये these are small headaches which will take some time in the beginning, but once the process is streamlined, then it is streamlined. The other perceived disadvantage of a private trust is that many people feel that perhaps it may be difficult to sell the trust property in future. Now here there is a confusion, and whenever I talk to people, they seem to be confused between the public charitable trust property and the private trust property. Now, if it is a public charitable trust, uski property बेचने में दिक्कत आती है because government has laid down certain rules and regulations. As I mentioned earlier, because public charitable trust, the property, the assets belong to people at large. तो वो जब property बेचनी होती है, whether it could be a house, a piece of land, whatever it is, you have to take permission from the government, certain certificates to be filed. And then after selling the property, again, you have to certify where are the proceeds being used. But that is for a public charitable trust. For a private trust, I haven't come across a case where they actually had to sell the property. I've only encountered 3-4 private trusts of people known to me. तो उनमें से अभी किसी ने बेची नहीं है या बेचने की कोशिश नहीं की है, पर एक ये धारणा है प्रॉपर्टी डीलर्स के माइंड में, कुछ लॉयर्स के भी माइंड में, कि ट्रस्ट प्रॉपर्टी बेचने में मुश्किल आ सकती है. पर मैंने देखा है, when I probe them, when I ask them questions, I invariably find that they are confusing and conflating public charitable trust with a private trust. And the last, I won't call it a disadvantage, but again, perceived trustworthiness of the trustees. Well, as I said earlier, this is the most important point. And even of cases where people don't form a private trust, but they know कि हाँ ये 2-3 भाई बहन हैं या रिश्तेदार हैं जो ख्याल रख लेंगे, trustworthiness तो वहाँ भी चाहिए ही ना. So trustworthiness is a factor. Whoever is going to take care of the person with disability, whether you form the private trust or you don't. The advantage to my mind of forming a private trust or mentioning things very clearly in your will or the letter of intent, or there is also an instrument called family agreement. Mentioning things clearly is where people know what their roles and responsibilities are, what they are expected to do. I find it extremely disturbing, strange, and extremely sad also that sometimes parents keep sleeping over it, and there is just an unspoken assumption that the other children will take care of it. And in 2 or 3 cases, I have found the other children are in other cities or they are abroad, and not even communication has happened. So that is sad. What are the takeaways that I would like you to have from this webinar? The first, it is very important to plan for the future of person with disability. Extremely important. Don't leave it to God's will. Bhagwan sab theek karega. You know, and whenever I find people telling me this, I ask them, आपने अपनी retirement planning की है? Medical insurance करवाई है? And the answer is खटाक, yes, बिल्कुल करवाई है. तो फिर मैं उनसे पूछता हूँ, वो क्यों नहीं आप भगवान पे छोड़ देते? रिटायरमेंट प्लानिंग बहुत अच्छी की है. रिटायरमेंट वाले एसेट्स कुछ गोल्ड में, कुछ रियल एस्टेट में, कुछ एफडी में, कुछ म्यूचुअल फंड्स में, कुछ शेयर्स में, वो सब किया हुआ है. हॉलीडे भी प्लान करते हैं तो बड़े अच्छे से प्लान की हुई है. मेडिकल इंश्योरेंस, हेल्थ इंश्योरेंस, इस पे कोई प्लानिंग नहीं की. It's extremely important to safeguard the interests of the persons with disability. Please communicate with the family members or friends, extended family, whoever you think are trustworthy. It's very important to communicate. I mean, when I find deathly silence, you know, and escapism and looking the other way, oh my God, it's killing. And it's also killing for the person with disability because he or she feels कि मेरा future secure नहीं किया गया है. I do not want the takeaway. Takeaway is not कि private trust बनाना चाहिए, नहीं. Takeaway is please ascertain, each one of you, each family needs to ascertain if private trust is appropriate for them. Therefore, also important to talk to your CA and lawyer, but before that, talking among family members and friends, कि क्या हमें private trust की जरूरत है? Is it appropriate to our case? अगर प्राइवेट ट्रस्ट की जरूरत समझते हैं तो ट्रस्ट डीड किस तरह फ्रेम की है, उसमें क्या क्लॉजेस लिखे हैं, फ्यूचर की क्या पॉसिबिलिटीज आपने असर्टन की हैं, दैट इज वेरी इंपॉर्टेंट. एज दे से, गॉड इज इन द डिटेल्स. But please also understand there is no perfect solution. I have also come across individuals who keep waiting for years and years and years कि अभी हमें perfect solution नहीं मिला है. वो कभी भी नहीं मिलेगा. You know, so please, silence, escapism and postponing is not the solution. Sit down, talk to your family members, do the best possible now. You know, my sort of favorite author, the American author Maya Angelou, do the best you can until you know better. Then when you know better, do better. Likewise, in your trust deed, keep that leeway, keep it open to some extent where future trustees can be identified. मान लीजिए आपने अभी 3-4 trustees identify किए हैं और चल रहा है, और आपको 2 साल बाद लगा कि ये 2 trustees interest नहीं ले रहे. Yeah? So then there should be a via media, a method or a plan कि अगले 2 trustees कैसे ढूंढे जा सके. So always keep that possibility open, slightly fluid. And you may have more information 5 years later. You may want to change some clauses of the trust deed. Please do so. But not taking a simple step, just waiting for the perfect solution or the perfect moment, that is, forgive me for saying this, that could be suicidal as far as the planning and safeguarding the future is concerned. This is our website. This is our email address. In case you have some questions, you could send us an email. Again, I mention I am not an expert. I have just shared what I have learned from different sources. Please consult your CA and lawyer. But more importantly, communication between family members and family friends to ascertain what would be the best option in your case. Thank you so much. We'll take questions now. Gurpreet, we can unmute people, or if you have something from the chat.
Yes, somebody has asked in the group that what is the difference between guardianship and trust?
Very good question. So guardianship is separate from the private trust. You, like under the new Mental Health Care Act, it has become very difficult to appoint a guardian. And there is also limited guardianship. And then some people opt for guardianship through the Rights for Persons with Disabilities Act. But for now, I just want to clarify that guardianship is separate from the private trust. Let's say you have 2 guardians for the person with disability. those guardians can be the trustees if you decide to form a private trust, but they may not be the trustees. You may, so guardians, you would like people who you think will, in terms of taking care of the person with disability. Whereas for trustees, it is also important that they understand how to the financial affairs and how to manage the property. So the trustees can be the same as guardians, but they may not be also. So it's completely possible that you have two different individuals as guardians and three different individuals as trustees for the private trust of the same individual.
Hello, can I ask a question, please?
Yes, please.
There is I have a son with MI, and we have registered a trust, a single beneficiary. But we have two trustees. Suppose one trustee is no more, then what happens to the trust?
Yes.
Does it become null and void? There are only
Yes.
two trustees.
Yes, yes. So minimum two trustees, and
And suppose
you
one
must.
dies.
Yes, yes, yes. So therefore, as I said earlier, in the trust deed, you must mention how future trustees would be selected. You know, so it could be, so if two trustees, one of them passes away, the remaining, the trustee that remains can choose another trustee, you know.
Can opt for, can the one, that the single one can opt for or suggest a name, another relative's name.
Yes, yes, yes. In that case, not suggest. The single trustee will have to appoint the next trustee. I mean, who would he
Okay,
suggest to? He's the only one remaining. So
So he
therefore,
has the power to appoint, and then again they have to go to the court where the trust was registered in front of the magistrate, that the new trustee will have to register everything, go through the whole rigmarole of registration office and all.
no, no, no. All
Just
that
can't put
rigmarole,
the name of anybody.
all that rigmarole is not required. And by the way, you don't have to go to the magistrate to register the trust. The local registration authority, the Tehsildar office or the registering authority for societies and trusts, you'll have to find out. It's a simple process. You don't have to go to the magistrate. And if you mention in the trust deed, so that is why I said God is in the details. Trust deed में आप वो terms and conditions किस तरह बताते हो? So it's very important to mention in the trust deed how future trustees will be appointed. So in this case, the remaining trustee, if it is the loan trustee, then he or she will have the power to appoint one more trustee. And you will have to lay down what would be the guiding criteria. He doesn't have to go back to the registration authority again or the magistrate. He can appoint that through a resolution, and then this resolution has to be signed. If you want to play very safe, once the new trustee is appointed, is on board, the resolution along with the original trustee can again be registered, or can again be sort of a copy can be submitted at the registration authority, but it is not cumbersome. You don't have to go to the magistrate.
Got it. Thanks a lot. One more question. Can a bank be a trustee?
Yes, I mentioned earlier, bank can be, and some of the banks have a trusteeship wing. So for instance, I think now even SBI has it, HSBC, ICICI. The only downside is they charge a fat fees. So unless your assets are very large and you can pay their fees.
No, middle class. No, not very large.
Yeah, so the unfortunate part is that they charge a fat fees, but this is something you will have to find out, you know. So for instance, I'm not sure how much does the SBI State Bank of India charge. They charge a certain flat fee, and then it's a certain percentage of the annual income. You will have to find that out, but I know that it would be a reasonable sum of money, a fat fees.
One more question. Can you
may I request, you know, just this sort of
one more last question, please.
Okay, quickly. Yes.
Oh yeah. If the beneficiary expires, then what happens to the trust?
Yeah, I mentioned earlier. So in the trust deed, you will have to mention the dissolution clause. And the dissolution clause is that trust stands dissolved when the beneficiary is no more. and the proceeds of the trust, whatever the property, financial assets that remain, will go to ABC. ABC can be individuals, ABC can be future generation, ABC can be some public charitable trusts. So you
Who
will have to
decides
clearly
that?
mention. You decide
Who
that.
decides?
Whoever sets up the trust, the
Because I did
parents or
not
the
get that.
guardians, they decide that.
No, my husband made the trust. He's no more. I'm a trustee. Can the trustee incorporate new members?
Yes, the trustee can. I would suggest that you, so I don't know what was mentioned in your trust deed, and now I would like to open it up to other participants also. So what I recommend is you please talk to the city that you are in. Please talk to your local lawyer or CA, and he or she will definitely be able to help. They'll have to read what the trust deed is, and then they will recommend, they will suggest to you accordingly. But yes, possible, yes. How? They will tell you.
If you have names of lawyer and CAs who deal only with trusts, can you please share? Because
No,
then they are
there are no such lawyer or CA, and some of them are very poorly informed, unfortunately.
yes,
So you will just have
I've
to
come
look.
across. They have no idea.
Which city are you in?
New Delhi.
So Delhi has thousands of CAs and lawyers. You'll just
Now,
have to
those who specialize
look
in
around.
only specialize in this kind of.
No. So one, they won't specialize in this because this is a very niche field. It's a relatively small field. They don't specialize, but there will be some knowledgeable CAs and lawyers. You'll have to find out. Unfortunately, I'm in Chandigarh. I don't know about Delhi. Sorry.
And one thing you left out is the rural land. The rural land, they have a different law of transferring, the property, the assets, non-movable assets, rural lands. When I went to find out.
My ignorance, and this is something that I am completely unaware of. I'm glad you mentioned it. So as I said, my knowledge is limited. I have no clue about rural land. No clue.
Rajni Sood ma'am, you can unmute yourself and ask the question. Kindly raise your hand if you want to ask any question. Rajni Sood ma'am, please unmute yourself and ask the question.
Can you hear me?
Yes. Please go ahead.
Sir, my question is that once you have a guardian, please let me know if I have a guardianship. I have a guardian for my intellectually disabled child. Then what is better and what is different if I form a trust? What benefits are there vis-a-vis guardianship and trust deed?
So, madam, as I said, and my knowledge of, I should also add, my knowledge of guardianship is very limited. But as I said, guardianship and private trust are two separate things. The guardians can also be trustees, but they may or may not be. Now, guardianship, having a guardian may not secure the person's financial and immovable property interests for his or her lifetime. I mean, if you have spelled that out very clearly in your will and whatever the letter of intent for the guardian is, if you have spelled that out very clearly and you have complete faith on the guardian, and the guardian also has the experience or the skill to manage financial affairs and property affairs, then perhaps it is okay. But
sir, I'm sorry to interrupt. When they issue the guardianship certificate by the various local authorities like Chandigarh administration, maybe Punjab, maybe different cities. So it is very categorically mentioned that the guardian will manage the movable assets and immovable assets only, nothing else. It is specified over there. Because this question was raised to me when he is not having any immovable property, then why? I said he is not having. Supposing I am not there, I mean, either of the parents ceases to be there, then the property is divided in amongst all the children in equal part or whatever legal heirs. Then he may become an owner of some share of property. So it may arise in future. So it is very, very categorically mentioned over there that guardian can only do this. It is specified. And secondly, what I understand is it is a state specific. Whatever guardianship rights are given, it is given for Chandigarh, not for other cities. Supposing the child settles in Bangalore or say Bombay or somewhere, then this guardianship certificate has to be taken from that particular state government. This is what my understanding is. So when you have a very limited, these days, everyone has a limited family members, either one or two siblings maximum. So even if you form the trust, you can't trust your relatives or anybody like that because you never know. You cannot, guarantee anybody's this thing, honesty. What I want to say is if you are either of your sibling or two of your siblings, I mean, they're the child sibling, they become the guardian. Where is the need to form the trust? This is what my always this questions, haunts my mind. There is no need to form trust unnecessarily to go into all these hassles. Guardianship certificate is fine. Because it specifically mentions movable, immovable, and it also asks you the details of the properties, the details of the bank account, blah, blah, whatever the affected person is having, like which bank account he is having, account number also they ask, which property you are supposed to give the details. Because recently I got it made. So after I got this guardianship certificate made, and the next question is that pension. Okay, I got the guardianship certificate made because there is a ruling in central government. Once both of us are not there, the disabled child will get the pension till he is alive. Family pension, we call it. It may not be the same amount. It may be some too. What I say is a carry on his life expenses and all those. So for that, this guardianship certificate will be enough because it depends upon the degree of disability also. Because if the child is not able to operate the bank account, certainly the guardian or the trustee, whosoever, I mean, whatever way you go, they will operate and they will spend on his behalf. If he can manage his bank account, then certainly there is no need to do all this. So what I want to supplement, what I want to say is that guardianship certificate is quite elaborative and sufficient as far as, because I made it because tomorrow, supposing we are not there, then that pension, whichever is given to him as a family pension, somebody should be there to really withdraw that money and spend on him. So that was my purpose. Trust has its own pluses and minuses because if you involve other family members, you never know. I mean, the lot of what I say is disputes may arise because child doesn't know anything or the affected person doesn't anything. Other members maybe become greedy tomorrow or something. So whomsoever you want to appoint guardian, I think he or she will be able to take care of, because they people have a very limited requirements. What I want to say is they don't want to expand their property. They don't want to expand anything. Only thing is livelihood, and that too comfortable living till they are alive. Their comforts should be.
I want to clarify on this retirement family pension. If husband and wife were in government job, and if they have pension, they have to give in writing to the accounts department while they are alive that my son with MI should be given the family. That has to be approved. And after your death, automatically your child will get the pension which you were getting.
Very right, ma'am. I agree with you. But you said this, that was the purpose of my obtaining guardianship, because you are not certain of life. So I'll just, I have forwarded it to my institution and they will record in their, make a note of it in their records. So tomorrow something is, it is always there as a permanent document. When we are not there, the family pension will be passed on to the child. Because tomorrow if we go after we decease, then tomorrow we go and claim the pension, family pension for the child, then it will be, unnecessarily so many hassles will be there.
You
So
have to do while you are alive, and you have to get it sanctioned. That letter should be there, in which
that's
your
right, ma'am.
yeah,
That's
in
very right.
which your son's or daughter's name is
Yeah.
written. That after my death, the family pension will go, and then
Yeah.
it has to be sanctioned by the accountant general. Only
Very,
then
no, ma'am,
automatically.
we are central government and we are a statutory organization and it doesn't go to
Ah.
central government. It is just done within our own organization. We are governed by mostly RBI rules. So that I am aware of, I'm taking care. Thank you very much. And I am quite aware of that was the purpose of obtaining guardianship certificate. Thank you very much, ma'am. That's what I wanted to say.
Thank you. Thank you so much for your inputs. So one, I again repeat, my knowledge and understanding of guardianship is limited. I learned that a guardian can also take care of the immovable property part. See, the trustworthiness, guardian भी तो आप उसी को लेंगे ना जो आप समझते हैं trustworthy है. और अगर आपको लगता है
Absolutely.
कि family members या siblings देख लेंगे तो again the trustworthy part comes there also. You know,
That's very right.
guardianship under the National Trust Act, Rights for Persons with Disabilities Act is easier to get. Guardianship for person with mental illness under the Mental Health Care Act is extremely difficult. और वो limited guardianship है. So what I again sort of say is and reiterate that private trust is separate, and that is why I said every family will have to ascertain. So maybe in your case, a private trust is not required, but every
Yes.
family will have to ascertain. So let me give you 2-3 instances. One, persons with mental illness, जहाँ किसी के पास guardianship है ही नहीं, and sizable property, you know, so there private trust could be a very useful tool, could be a very useful medium. I have also come across cases where even though the sibling takes care of the person with disability, the person with mental illness quite well, the parents are comfortable with the sibling taking care, but this person with mental illness, whether it's paranoid schizophrenia or something else, is deeply suspicious कि ये मेरा हिस्सा खा जाएगा. ये बैंक अकाउंट से पैसे तो निकलवा रहा है पर मेरे उस पे नहीं डाल रहा. You know, what do you do in those cases? So that is why I said every family, every individual, it will be a case by case basis. So essentially,
Yes, very right.
every family will have to sit down and see what is their scenario. Will just guardianship suffice? And guardianship for person with intellectual disability under National Trust Act, Rights for Persons with Disabilities Act is relatively easy. For person with mental illness, limited guardianship and extremely difficult. What this person's scenario is, what is the property that we want to transfer, you know, the assets under consideration, and what would be the best vehicle to do that.
Sir, as you rightly said, in the trust, there are 2-3 trustees. So, you know, there is a check over the other person. I mean, one upon the other, number one. Number two is when the family has a sizable asset like property or maybe money or other movable assets, then trust, I think, is beneficial. But in case of a limited this thing like pension or maybe something, 1 or 2 things, question of livelihood and you know, management of the expenses, then I think this guardianship certificate will suffice. It all depends upon individuals' financial situations.
Yes, yes. And I
Hello.
My last question is,
Hello.
do we need to have
Hello.
80G or 12A?
for private trust,
Hello.
12A 80G is not required. That is public charitable trust. Private trust not required. Yes, please go on. The gentleman who was asking. Hello.
I've typed
Hello.
in question with
Yes.
guardian A and guardian B. Can you please answer that?
Sorry, please repeat. Your voice was breaking.
Hello.
I have typed in my question about guardian A and guardian B. How do we get the guardianship if Karan
Yeah.
is not?
I have to confess my ignorance. My knowledge of guardianship is extremely limited, and that's not the scope of this webinar. So I apologize. I won't be able to answer the question
Hello,
on
sir.
guardianship. Yes, please go on.
May I request?
Yes, yes, please.
There are two views on the guardianship.
Your
as well
voice
as
is
the
breaking.
guardian as well as the trust.
Hmm. Your voice is
Yes, yes,
breaking.
Ah,
Please check your
because
connection. or-
if the guardianship under national trust says the guardian should remain within the district of the local level committee.
Hmm.
Supposing if you are in Chandigarh and the guardian is sitting in Delhi, and appointment of guardian may be difficult. Number one.
Right.
Number
Right.
two, if the guardian himself is dead after the these parents, then there will be a problem. In that case, having a trust will be beneficial because the trustees can be identified again and again to function as a guardian, number one. Number two, we can choose some trustees within the district so that they can be appointed as a guardian by the National Trust. This is my views. So both are required. Both
Thank
are
you.
required.
Thank you so much for sharing very valuable information and insight.
Yeah.
Good information, sir. But if the question of only family pension is there, or sort of, just for operating the bank accounts, the guardians need not to be in the
No,
same
under,
city.
under
What I want to say
national
is because
trust,
they have
national
like,
trust, it is clearly given that the guardian
Yes.
should live in the same district.
Sir, my question, my submission is that pension comes in the bank account, which has a facility you can withdraw anytime, anywhere.
Who will withdraw?
So guardian can withdraw the
Guardian, who
family
is
pension. No?
appointed? Who is appointing the guardian?
Whosoever is the guardian for disabled.
Local level committee by the national trust. Local level committee is the magistrate of the district or the district collector.
I agree
Revenue
with
collector.
you, sir. My submission is once the guardian is appointed, correct?
Yeah, yeah.
And supposing parents are not there. What I want to say, sir, that supposing parents are not there, no guardian has to, make provision for the expenses through the pension, through the family pension. He can
Family
withdraw
pension,
the money.
he may get as long as he is alive. Suppose that guardian himself is died, then what will you do?
That your point is very valid. If guardian is not there, then trust is beneficially. No,
Yeah,
as
yeah.
you.
In that case, private trust has to appoint another guardian and register with the local level committee. Then only there will be continuity of getting the family pension.
No, sir. Just listen. I think you are not getting my point. What you are saying is 100% correct, sir. What
Okay.
I am submitting is like you said that guardian has to be in the same place as the
Yeah,
disabled
as per National Trust Act, it is given that the guardian should stay in the same district.
My submission
Under RPWD Act, I don't know that you have to represent to the State Commissionerate of Disability.
May I request that this technicality can be discussed later. We'll take some different questions. I was just reading the chat box.
Okay.
Thank you so much. Thank you so much for your inputs and insights. Seema Jain has raised her hand, but before that, I quickly want to. Sneh Devgan has requested, a copy or a template for a private trust deed. So just through the internet, you will find many sample trust deeds. You can also send us an email and I will send you a template for a private trust deed. The other question, the other chat box I was reading, people have mentioned, wouldn't it be better to have more financial assets rather than the headache of property? Yes, any day preferable. This is what a CA or a lawyer or most people will tell you, that as far as possible, keep it liquid assets. because you don't know which city this person will live in, whether this person will stay at home or go into a rehab home, a group home. So as far as possible, liquid assets, financial assets, annuity plan, one very senior gentleman in our circle is using, and he's very happy with it, the LIC annuity plan that I shared. Other options are bank FD, postal deposit, mutual funds. So yes, as far as possible, financial assets are much better than immovable property assets, which may be a headache. Seema Jain had a question.
I want to say that we Shri OPS ji done that the legal guardianship that is from the National Trust, and it is not they have only given only four disabilities, but in the state the guardianship we can easily, but it is not very tough with the state disability intervention of state disability commissioner and with the officer of social welfare department. Through this we can the PMI parents can take the guardianship through the intervention of disability commissioner with the social welfare department, and so this can be in the state.
Thank you, Seema ji. Thank you. So I'll just quickly read. So I think we'll stop here. And in case you have any questions, please send us an email. You will find sample trust deeds on the internet, but if you want us to send, just send us an email and I will send you a sample trust deed. I again repeat, the takeaway is not that private trust banana hai humko. Takeaway is that we need to sit and discuss what is the best vehicle. The takeaway is that we must communicate with family members, with our children, with the extended family who need to be involved, and must plan for the future. So that is the takeaway. Thank you so much. And do send us an email if you have any question that we could not answer here. My apologies again if I haven't been able to answer some of the questions because my knowledge is limited. I learned something new about guardianship today. Thank you so much.
Thank you so much.
Thank you so much. Thank you.